This is Talk 1470.
Talk 1470.
WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to Musca Law Radio, a program dedicated to criminal defense with attorney John Musca. Mr. Musca has offices throughout Florida, including Broward and Palm Beach counties, and has devoted his legal career to representing clients on all criminal defense matters. Mr. Musca has been a member in good standing with the Florida Bar since 1999. He is a lifetime member of the National Association of Criminal Defense Lawyers, the Florida Association of Criminal Defense Lawyers, and NORML. In 2012, he was selected as a rising star by Super Lawyers, a distinction reserved to the top 2.5% of all criminal lawyers in Florida. For the past 4 years, Mr. Musca has been designated one of the top 100 trial lawyers in Florida by the National Trial Lawyers Association. He also enjoys a perfect 10 rating with AVO, a respected independent lawyer rating organization. If you or someone you know is under investigation or accused of a crime, or if you have any questions related to criminal law, you don't want to miss today's show with attorney John Musca. To watch the show stream live, visit muscalaw.com. That's MUSCA law.com, and click on the radio link. And now, here's attorney John Musca.
Thank you so much, Duff. Welcome back to the show, South Florida and listeners everywhere, streaming live on muscalaw.com. We had difficulties the first time around with streaming capability on our website. Able to confirm now that is no longer the case. So log on from your iPad, from your iPhone, what have you, desktop, www.muscalaw.com to stream live. We're continuing our discussion today about DUI in the state of Florida. This is DUI Part 2. Last week we dedicated the show to the first part of DUI defense, explaining the general introduction and overview. And this time I pledged to take more callers. Last time we just simply ran out of time, and this is, after all, a program dedicated to educating the public as much as we can to relay the experience that we've collectively assembled over the years for the benefit of our listening audience and those that are joining us. So with that said, DUI is a crime in the state of Florida, and I just want to touch on a quick parameter, an overview. When someone's arrested under suspicion for DUI in the state of Florida, it triggers the beginning of 2 separate cases. It's important to remember that there is a DMV component and there is a criminal DUI case. These are 2 totally separate cases, but the key thing to remember is if you're arrested under suspicion. In other words, if you're arrested, you've merely been charged. It's very important to understand that. It's really important to remember that, and it's more important than ever that you engage competent, qualified counsel to address your legal matter as soon as possible. So with that, that's a general overview. We're going to flesh out those 2 cases in greater detail later on, the DMV case and the DUI criminal case, what's at stake, what's involved, as we move forward through today's show. But right away now, we're going to take our first caller, and I believe that's Teresa from Boca Raton. Teresa, are you with us?
Yes, I am.
How are you? Thank you for joining.
I'm from Boca Raton. Sometimes I have a couple drinks with my friends, and if I were pulled over, how could I prepare myself? Okay.
That's a good question, Teresa. Thank you for joining us. To prepare yourself for DUI, if you happen to be in the unfortunate situation, there are some very important action steps you can take in advance. First and foremost, you want to make sure that you have your materials ready. So in other words, I always advise clients, I always advise people in general to keep a copy of your driver's license handy at all times. Put it somewhere where you know it's readily accessible and available. Also, have your registration ready and also have your proof of insurance ready. Okay. Oftentimes you can place that in a visor up above, or in the center console. But in any case, before you get into the car, Teresa, you always want to make sure that you know where those materials are at all times.
Okay.
Very important.
Usually I keep them in my glove compartment and that, except for my license, but that's just something I kind of wanted to know.
Glove compartment's good as long as you know where in the glove compartment they are. For example, something that law enforcement routinely relies upon to present evidence of guilt is that when the person's arrested, they're fumbling around for their information. They're trying to locate their driver's license. They're trying to locate their registration card. More oftentimes than not, that's part of the probable cause affidavit in the police report, where they will cite in there that the person was fumbling around, they were nervous, and they must have been impaired, they must have been intoxicated, because after all, they couldn't locate the driver's license, and they couldn't produce that and have it readily available. So, Teresa, at all points, you want to make sure that you have those materials readily available at all times. In addition, there are a number of other things that you can do, again, if you find yourself in that situation. Now, by no means am I encouraging anybody to have some drinks and go out and drink and drive. That's not what your question is. Your question was, if you find yourself in that position, what action steps in advance should you be aware of? Can you possibly take to be in the best position in that instance? Also, I always advise people, don't take side roads. That's what law enforcement typically look for, are people that are going to be taking side roads and shortcuts.
That's a good thing to know, because that's normally something you think, oh, don't be on a busy road. That's where the cops are at. Never thinking that, oh, they're on the side roads.
They're waiting on the side road. Oftentimes they know the shortcuts. They know what to avoid. If you see police activity, I think it's common sense. If you see lights, you want to avoid that as well. Not to make it obvious that you're avoiding it, but you're simply avoiding it, getting out of their way. Many people think that, hey, I have nothing to hide. I'm gonna breeze right by law enforcement and take my chances. Bad idea. So you want to avoid law enforcement in those cases. You want to take the main road, main thoroughfare as much as possible. I mentioned when you get stopped, you want to have your materials readily available. Don't be fumbling. Don't be nervous. Just be calm and collected. I know that's easier said than done. Really and truly, I recognize that. But in that case, you want to offer up as very little evidence as possible, Teresa.
Okay. Well, thank you so much for the information. I'm glad that I called in.
Thank you very much for calling in, and I'm going to flesh that out in a little bit greater detail with respect to remaining calm and collected when you're pulled over. You obviously want to be able to produce your driver's license, your registration, and your insurance ID card, and you want to advise law enforcement in that case that you're willing to cooperate with their investigation. You want to be obviously as polite and respectful as you can, but you don't want to give up evidence. What is evidence? Field sobriety exercises and a breathalyzer result. Now, if you've had nothing to drink, ordinarily there's no harm in agreeing to blow. However, if you find yourself in a position where you've had some drinks, ordinarily it's the best decision to not blow and to not perform the field sobriety exercises, because those are the two main forms of evidence that prosecutors will rely upon to try to prove guilt and to try to prove impairment. It's also important to remember that it's not a crime to drink and drive in the state of Florida. If it was, you wouldn't see parking spots in front of bars all over the state. In other words, you're allowed to drink, you're allowed to go to a bar, you're allowed to drink, and you're allowed to drive, but you're not allowed to drive impaired. And impairment is the key word. That's what the prosecutors need to prove, that you consumed so much alcohol to the extent that your normal faculties were impaired. And the main principal forms of evidence the prosecutors are going to rely upon to prove impairment: the field sobriety exercises and the breathalyzer result, as well as any admissions that you make. That's another point in responding to Teresa's question, how to handle the situation better. Make sure that you don't make any admissions against interest, things that you say that could be used against you, because anything you say in the context of a DUI investigation can and will be used as evidence against you, you can be sure. For example, the officer says, "Where are you coming from?" The subject says, "I'm coming from a bar and I had 3 drinks." Absolutely not. Law enforcement asks where you're coming from. The answer should be, "If I'm being investigated for a DUI, I would prefer to defer those questions to my attorney, and I'm not comfortable saying or doing anything unless or until my attorney is present." So you don't want to make any admissions or statements either. Simply cooperate, present your ID card, tell him who you are, and at that point, more than likely, he will then ask you, or she will ask you, to if you wouldn't mind voluntarily submitting to the field sobriety exercises. At that point, folks, like we discussed in an earlier show, I can all but assure you the law enforcement officer has already made up his mind that you're suspected of DUI and drunk driving, and chances are really good you're going to be arrested anyway. I think I can count on my hands the number of times people have been let go after being removed from their vehicle or invited to participate in field sobriety exercises. It doesn't happen ordinarily. As a general rule, when you're asked to exit the vehicle, you're going to be arrested for DUI. At that point, what they're trying to do is gather together and marshal together as much evidence as they possibly can to lay the foundation for an eventual conviction. That's their job. Your job, your responsibility is to exercise your right to remain silent, Fifth Amendment privilege against compelled self-incrimination, some Fifth Amendment privilege and right that you have. It's inalienable, and it's yours, and it belongs to you exclusively. So make sure you honor that, make sure you exercise it. At that point, the investigation will pursue. Chances are you will be arrested, but then, as I always say, public streets are public domain. Law enforcement has their say, but then at that point, it's time to turn things around and engage the right legal team, competent, qualified defense attorney to step in and handle the matter in the courts. And the less evidence that the prosecutor has that they're able to use and present against you, the better. Great question. Teresa, I thank you for joining us from Boca Raton. I believe we have yet another caller on the line. I think we have Tina. Tina on the line. Tina, are you with us?
Hi, John.
How are you?
Fine, thank you.
Thank you for joining us.
I weigh about 160 pounds, and I wondered if the legal limit has anything to do with weight.
Absolutely. If you weigh 160 pounds and you're a female, you're looking at probably 2.5 to 3 drinks.
2.5 to 3 drinks.
2.5 to 3 drinks.
Okay.
Depending on, you said 160 pounds?
Yeah.
Okay, so 160 pounds, probably 2.5. Would put you over. Now, there's other variables involved, of course, such as if you had anything to eat. A lot of the DUI cases that we get with very high blows involve people that had nothing to eat, almost invariably throughout the day. So,
yeah, I can understand that.
Also, Tina, following up on Teresa's question earlier, make sure that if you go out, make sure that you eat. Make sure that you have plenty to eat, enough so that you can have a couple drinks and not have to worry about blowing over the legal limit if you find yourself in that position. But to answer your question, you're looking at 2.5 drinks. If you were to blow, now of course, I'm recommending that if you had 2 drinks, that you decline the breathalyzer.
Now, does it matter like the length of time in which you have these 2.5 drinks, or is it just consumption?
Normally your body absorbs one drink an hour. So you can figure if you had 2.5 drinks over between an hour and hour and a half time frame, you're going to blow over the legal limit. So yes, the time frame over which the drinks were consumed also plays a role. How much you had to eat that day, how much you slept that day, any other medical conditions, any prescription medication you're taking, all that plays a role. We break all that down and we analyze it. We have to when we take on a DUI case involving a breathalyzer result. Really important, Tina, to understand also that, just because somebody blows over the legal limit, that doesn't necessarily mean that you're impaired. 0.08 is a threshold for adults. 0.04 is a threshold for CDL holders if a CDL holder gets arrested under suspicion for DUI, and a 0.02 is a threshold for somebody under the age of 21 who gets arrested. Let me flesh that out because I think it's very important. Somebody under the age of 21 gets stopped. Law enforcement in the state of Florida come by and they use a portable breathalyzer device. If the person blows over a 0.2, then the person under the age of 21 is typically cited for the administrative suspension, and they're going to have to go through the administrative suspension process. I mentioned earlier that there's typically a DUI case and a DMV suspension case. Oftentimes, if you're under 21, what we see are DMV suspension cases only, because oftentimes the folks under the age of 21 that blow over a .02 are simply not charged with DUI. It's discretionary, of course, but they're not charged. .04 is the CDL holder threshold limit for administrative suspension, and a .08, of course, for all other adults. Getting back to your question, 2.5 drinks is going to put you over the legal limit. In that case, I would advise you not to blow.
Okay, thank you.
Thank you. Thanks for joining us. We're talking about, how very important it is to exercise your Fifth Amendment privilege and your right to remain silent, to not offer up and give up evidence. Tough to do, and I understand that. And the tendency, what most people think, is that by cooperating with law enforcement, you're going to help out your cause. You're going to help yourself. That's not the case. As I mentioned earlier, law enforcement, as a general rule, are there to do a job. Some of them do it very well. Some of them don't. The field sobriety exercises, law enforcement are instructed to do those according to the National Highway Traffic Safety Administration manual, which sets out rigid criteria to instruct law enforcement how to perform those exercises. And the breathalyzer result ordinarily is administered under the guidelines of the Department of Transportation. So law enforcement does have rules, they have guidelines, they have strict criteria by which they administer the field sobriety exercises and the breathalyzer. And it's important, if you find yourself in a situation giving up this evidence because somehow, some way you feel that it's going to benefit you when it won't, then you definitely want to make sure that counsel evaluates those two principal forms of evidence to see if there's problems with either one of them. And oftentimes there are. The reality is law enforcement does not administer the exercises properly all the time across the board. The reality is they get away with it, and the state gets their conviction because many people do not consult counsel early enough, or they consult the wrong counsel that simply doesn't have the experience, knowledge, and qualifications to handle DUI cases appropriately. So very important that you engage counsel early on, and that you don't procrastinate, and give yourself a full shot to make sure that your case is fully evaluated. That's probably the most important advice I can give too. There's no benefit and advantage whatsoever to delaying and thinking that the problem's going to go away itself. It won't. If you're arrested under suspicion, really, if you've been asked to remove yourself from the vehicle, you're going to be charged with DUI. And so the very next day, or that night even, it's time to reach out to defense counsel. So moving on to our next caller, we have Jerry from Broward. Jerry has a question. I mentioned last time that we didn't take enough callers, and I want to make sure that we have that I'm able to answer as many questions as I possibly can within the hour that we have together. The phone number, once again, is 888-565-1470 on WNN 1470 AM radio. That's 888-565-1470. I am here for you, and I'm here to answer your questions to the best of my ability. Jerry, are you with us?
Yes. How are you doing, John?
How are you? Thank you so much for joining us.
Oh, you're welcome. I got pulled over. It's my second DUI. I blew a 2.0.
Well, a 2.0 and you're dead. So probably a 0.2 or higher. Go ahead, sir.
0.2. It's my second DUI, and it was my second one was 20 years ago.
Okay.
And I'm wondering if that's going to haunt me, if that's going to come into play?
Okay, so I always have to start with the disclaimer that the facts and circumstances of each case are different, and I can answer your question generally that if you're concerned about the second DUI the first DUI coming into play, it certainly does. You mentioned your first one was about 20 years ago?
20 years ago. I'm 43 now, so.
Okay. So in this instance, you're looking at a DUI second outside of 5 years. And I mentioned earlier, Jay, I don't know if you were with us earlier when I mentioned that two cases have been created as a result of your DUI arrest. The first one is the DMV case. They took away your license. Your license is now suspended for a 6-month period of time. The only way to get your license back and get it reinstated is to file a petition for what's called a formal administrative review, which is a process that your defense lawyers need to go through in order to reinstate your license. Oftentimes, the question I get is, well, if I blow over the legal limit, they're going to take my license away anyway. Sure, they are, and it's going to happen right away, but you're entitled in the state of Florida to a evidentiary hearing, a formal administrative review, and that's a process by which defense counsel files a petition with the DMV, which is your declaration to the DMV that you're challenging the suspension and that you absolutely have a right to do that, and have defense counsel look into all issues related to that. That's roughly a 2-month process. Now, when we file for that, we obtain for our clients a driving permit of roughly 42 days, Jerry, which will allow you to drive for that period of time. The 42-day driving permit gets us through the DMV appeal process. So you'll be driving all the while your defense lawyers are working on looking at all applicable issues, including but not limited to the breathalyzer machine, and performing a full-blown evaluation of the machine and the sample that was produced in order to determine if it was properly in order to determine if the result produced was properly done according to procedures and guidelines. Now, what do we look at? We look at everything. What machine was used? Has it ever malfunctioned? Has it been properly tested, serviced, maintained, and inspected according to guidelines? Are the annual reports in order? Was it evaluated a month before? Was it evaluated a month after? All of these things we look at. We look at, has a machine been properly calibrated? These are things that defense lawyers have to look at. If we don't, it's a dereliction of duty, and it's irresponsible on our part. So we cannot presume for a moment that your .2 or higher blow is accurate, because to do so would be to presume that you're guilty when, as you know, Jerry, when you're arrested under suspicion for DUI in Florida, you're presumed innocent. So as such, we have to presume that all of the evidence is false as well, including the breathalyzer. So they're saying you blew a .2 or higher. You're telling me that they told you that you blew a .2 or higher. I'm saying false. Prove it to me. We file a demand for the intoxilizer logs. We file a demand for the breath affidavit, anything and everything that they have. I want to know if implied consent was read. I want to know if there's any applicable constitutional law violations. I want to know if there's any rules of criminal procedure that have been violated. I want to know everything that happened from the very moment that you were stopped all the way through and up to the point that you were booked into the jail facility and released. Those are all the things that we look at. To answer your question a little bit more pointedly, DUI second, this would be considered a DUI second outside of 5 years, Jerry, which triggers the applicability of enhanced penalties because of the prior. Excuse me, let me back up. This triggers enhanced penalties upon conviction because of the over a .15 blow. So in this case, on the DUI side, if you are convicted, your jail exposure is no jail up to 12 months, a fine of $2,000 to $4,000 plus costs and costs of prosecution, a driver's license revocation from 6 months up to a year, between 6 months and 12 months of probation, DUI school phase 2, which includes a substance abuse evaluation, community service hours, victim impound, which is typically 10 days, unless that's waived. What is that? That means that you have to have your car disabled somewhere, and they come by and they put a boot on it. That's something that you need to pay for as well. That's a vehicle impound, unless defense counsel is able to have that waived. And also, this is something important. The ignition interlock device will also apply to your case upon conviction, Jerry, which is a device that needs to be installed in your vehicle, which you need to blow into before your car will start. That is also at your expense, that you need to pay for, and that's a minimum of 2 years on a DUI second offense outside of 5 years with a BAC level over a .15. There's also the victim impact panel, which some counties require and some don't, which is also some form of instruction and schooling that you need to submit to as part of your probation. Now, probation is no walk in the park. There are monthly reporting obligations. There's monitoring fees. There's a number of things that you need to do while you're on probation. You always have the watchful eye of Big Brother or the state of Florida looking over you. So, again, these are enhanced penalties that apply in your case upon conviction for DUI second outside of 5 years with a BAC level over a .15. Something obviously that the listening audience doesn't want to find themselves in a position. You're in that position now. I understand where you are, and this is what your exposure is. And as such, it's important that you get a hold of counsel right away to explore your rights and look into every possible detail to try to vindicate your interests on this.
Well, I appreciate that. I'm going to follow up on that, especially trying to keep my job. Get to work.
Right, Jerry. That's another question I get too. Should I notify my employer? My response on that ordinarily is no. Unless you're contractually bound to do so. If your contract is such that when you signed up with your employer, they expect you to declare these things, and you sign that contract, then you're obligated to report it. Otherwise, if you're not, and you want to run the risk, now also there's the additional concern now of mugshots. That's another frequently asked question. That we get, when someone's arrested for DUI, what do I do about the mugshot? Can you do anything to take it down? Ordinarily, no. Due to the Freedom of Information Act and the broad sunshine law that Florida has, that's public domain. So these agencies, I'm not saying that they're the most scrupulous of all agencies, but there are outfits out there that will publish your mugshot, and for a nominal fee. Oftentimes, it's not so nominal. I've seen $350, $400 in order to remove it and take it down. They will do so if you pay them. So if you're not contractually obligated to notify your employer, I would advise that you do not do so. But bearing in mind that you then assume the risk that someone's going to find you in the search engines. And see that you have been arrested, and see your mugshot, which doesn't go away anytime soon. It will lose relevancy over time, and unless you engage and pay these individual vendors to remove the site, which most people don't want to do, it's going to stay up there. So. I appreciate your concern, Jerry, on wanting to keep things in place. The other layer too is it depends on your the relationship you have with your employer. Are they going to be understanding? Some employers want to know. Okay, so they find out that the employee was arrested for DUI. Is the person conscientious about the case? Have they engaged an attorney? Are they taking it seriously? Have they voluntarily taken steps to position themselves for a favorable outcome? It's a lapse in judgment. 90% of our clients, if not more, are first-time offenders. We certainly have a fair share of multiple offender DUIs, DUI second, third, fourth, ninth offense. We have DUI cases with aggravating factors such as property damage, accompanied by a minor, DUI involving an accident, DUI involving serious bodily injury. We've handled DUI manslaughter cases involving 2 or 3 victims. So On the scale of DUI cases, yours involves the aggravating factor, two aggravating factors, I would say, Jerry. One is the blow over a .15. You mentioned a .2, and secondly, the fact that the prosecutor is certainly going to be aware of the prior DUI. Although, let me qualify that. Was that prior DUI out of state or in state?
In state.
Okay, if it was in state, more than likely the prosecutors are gonna pick it up. There's a database called the NCIC, which is a national database that accesses all prior records of anybody arrested for DUI. I will say, however, and remind the listening audience that the filing decision on a DUI, like most criminal charges, is discretionary, which means a prosecutor may file this as a DUI second outside of 5 years with a BAC over a .15, or they may not. If the prosecutor honored by the arraignment date, the prosecutor is obligated to make a formal filing decision, and if the prosecutor determines, based on the information that they have, that this case warrants or deserves to be filed as a DUI second, then that's what they'll do. A conviction for which will trigger the enhanced penalties, which we discussed earlier. So,
okay, all right, okay, all right. Well, my boat, I got to row it. Well, I appreciate it, John. Thank you very much.
Thanks for calling in, Jerry. Thanks for joining us. Appreciate it. So, alluding to what we discussed earlier, I mentioned early involvement. If I say it 3 times, if I say it 5 times, if I say it 10 times, I'm not saying it enough. Having defense counsel work on it early to secure the best possible outcome. For example, in Jerry's case, I don't know if the prosecutor has made a formal filing decision. Assuming that they have not, then there's a reasonable opportunity for his legal team to intercede and act on his behalf early, in between the date of the arrest and the formal filing date, which is the arraignment date. And by that I mean there's action steps that we can take now in order to position himself so that the prosecutor is aware that on or by the arraignment date, here's what our client has done. Well, he's enrolled in the DUI school. He's submitted to some community service hours. He's gone ahead and done a substance abuse evaluation, and he's in the process of following those recommendations. Prosecutors are political people. They want something to be able to hang their hats on. And that's what you need to give them as a defense lawyer. You have to give them a reason how and why they should maybe not file this as a DUI second. Maybe they're going to file it as a DUI first, because after all, they're responsible for exercising prosecutorial discretion. And if your legal team gives them reason to do that, oftentimes they do. So very, very good question from Jerry and Broward. Now we have, I believe we have Sarah from Plantation on the line. Boy, I told you we were going to take some calls, and we're taking some calls, so that's good. Sarah, are you with us?
Hey, how you doing, John?
How are you? Thanks for joining us.
Hey, thanks. I got a question. I'm 36, and on Saturday night, I was out with my friends, and I got pulled over, and I've never had a ticket or anything, and I got a DUI. And, they have you get out of your vehicle, and then they look through your vehicle, and they also found a little under 2 ounces of marijuana in my car. And I'm wondering what I should do. I didn't blow.
Okay, so there was marijuana found in your car, and you refused a breath test.
Yes.
Okay. Well, as I mentioned earlier, as I mentioned earlier, I'm sure that was a good move, statistically, based on the cases that we've seen over the years, and I'm referring to, of course, thousands. The marijuana charge is an important one to take into account. If you're convicted of a marijuana charge, if you're convicted of certain enumerated drug charges in the state of Florida, a mandatory 2-year suspension of your driving privileges is called for. Now, that applies whether you're arrested pursuant to a DUI arrest or not. In other words, if you're walking down the beach and law enforcement stops you and you have a joint in your ear, or you have a marijuana on your person, or if you're constructively possessing marijuana, which means that it's within your area of reach or control, and you're arrested for marijuana or cocaine or certain other enumerated drug charges, if you're convicted, you'll lose your license for 2 years. In that case, you're not even in a vehicle. So there is no direct nexus or connection to the circumstances of the arrest and the actual suspensionary period that you have to go through. So it's important that marijuana charge is also handled. There's a tendency that some defense lawyers do of trading one for the other. In other words, okay, we'll agree to a conviction on the marijuana charge if you agree to a lesser offense on a DUI case, or vice versa. That's not the best strategy either, because in either case, a criminal conviction is a criminal conviction. And when you apply for a job and you're asked if you've ever been convicted of a criminal offense, I'm sure most people would prefer to not have to put anything on there, whether it's a drug charge, a DUI charge, what have you. So, so strategically, it's important that all efforts are geared toward making sure that there's no conviction on either charge. So every opportunity needs to be explored, every avenue exhausted in that regard, and obviously every opportunity exploited.
When I was in that situation, the police were insisting that I blow into that little machine that they have and stuff like that, and they had like flashlights in my eye and that, and I don't know, somewhere in me it said no and that, but they were kind of upset with me. Is that like normal for them to be upset with me about that?
Well, law enforcement, they're going to be upset because they're out to do a job. So they're there to gather as much evidence as they possibly can to lay the foundation for an eventual conviction. Most of the time, they're not there to be nice guys or nice women. They're there to do a job. So, good question, Teresa. We get that question a lot, where people are exercising their right to remain silent. They're not giving up evidence, and the officers don't like it at all. And so, that's okay, because you're going to let them do their job, and the hope of anybody in that situation is anybody in the listening audience that has not yet been in that situation is you're going to do your job and exercise your right to remain silent. But no, that's typical. That they would behave in that manner in response to you not giving up the evidence that they asked for.
All right. Well, I thank you so much for your time, and I'm going to try and seek out a good DUI attorney in Plantation. That can make sure because I'm still young, I don't want to have anything on my record, and I just made a grave mistake. It was a party for my friend that's getting married, and everything gets a little bit crazy sometimes, and I put the key in the ignition and went drive. So I have to suffer those consequences, but I just appreciate you taking the time with me and that.
Teresa,
so, Don, I hope you have a great day.
Yeah, thank you. Let me back up a little bit, though. I wanted to ask you a question with respect to did you voluntarily offer up the marijuana, or did you?
No, it was kind of just sitting there. It wasn't like it was just there. I don't know if it fell out of my purse or what. They didn't have to look very hard for it. It was just there. I don't remember exactly the situation, but. No, but after that, of course, they're going to really look through the car and make sure that, there's not anything else.
All right. Well, pursuant to a DUI investigation, law enforcement has a right to search your vehicle pursuant to the investigation. They're entitled also, after your arrest, to inventory the vehicle. So that's going to happen. But any opportunity you can, for example, we receive a lot of calls of people that are not being investigated for DUI that are stopped, and the law enforcement ask them for permission to search the vehicle. Absolutely not. The response then becomes, well, if you don't allow us permission to search your vehicle, we're going to summon the dogs and we're going to bring them. And your response at that point should be, that's fine. And you're patient, you're calm, and you're going to let law enforcement do their job. And as I mentioned earlier, the hope is that you're going to do your job and exercise that sacred and pristine Fifth Amendment privilege against compelled self-incrimination. Let law enforcement do their job. Don't block their efforts. But at all costs, you always want to step in, exercise your right to remain silent, and be as respectful and courteous as you can. I respect and appreciate what you're going through, as many of our clients have over the years. Just hang in there and make sure you consult competent counsel to address your issue. Thanks again for calling.
All right, thank you. Have a great day.
Thank you. Now. Great. Bye now. So now, also a very frequent question that I receive that I have received over the years relates to expungement. Somebody's arrested under suspicion for DUI. It results in an eventual conviction. I cannot tell you how many calls a week we get from people who are convicted of DUI and ask me if they could have their record expunged. The answer is no. Unfortunately, the state of Florida doesn't allow a conviction for a DUI to be expunged from your record, and it's unfortunate, but that's why I always say that you have one shot at it and one shot alone. That if you're arrested for DUI, arranging counsel to secure a favorable outcome is critical, because if there is an adjudication of guilt, which is absolutely required by statute, that the adjudication is mandatory, then there's no opportunity to expunge that or have that obliterated. It's basically a life sentence. It's on your record for life. So that's an important thing to consider. And again, there's only so many things that we could do after there's a conviction for DUI. Now, you do have some rights. For example, if you enter a plea within 30 days, you have a right to file an appeal. If you enter a plea and you're sentenced to a DUI, you have 60 days ordinarily to file to have your legal team file a motion to mitigate. But I could tell you the likelihood of prevailing on either one of those scenarios is not really all that great. So take your time, relax, be calm, be patient. Let your lawyer do his job. I oftentimes say time is a defense lawyer's best friend. The cases that we have been able to obtain the best possible outcomes are those that age over time. Because for various reasons. First of all, that gives us plenty of opportunity to do what we need to do, to get in here, to identify pretrial motions that we can file, to identify points of attack that we can pursue on your behalf, to make every possible challenge and assert every possible argument that we can on your behalf. The more time that we have to do that, the better. That's what's nice about defense work. We can continue these cases. We can age them as long as there's a good faith basis to do it. We can't ask for a continuance if the basis is frivolous, but if we have reasonable grounds, justifiable grounds for continuance, and the judge grants our continuance, or the prosecutor agrees to it by stipulation and the judge goes along with it, then we're good to go, and we have all the time that we need. The other advantage too of delay, I shouldn't say delay, but moving these cases along is prosecutors are busy, and if the prosecutor has 50 cases at the time of your arrest that they're prosecuting, you can only imagine how many cases they're going to have 5 or 6 months down the road. So we want to make sure that we have plenty of time to do what we need to do. We also, unless the prosecutor is willing to negotiate a resolution and settlement early, we also want to make sure that we take our own time to investigate every possible argument that we can pursue on your behalf. So that's also a very important benefit. Working on these cases over time, over an extended period of time. We're not in a hurry to resolve these cases. If the prosecutor is, that's typically when they come out and when they're asking for, or when they're offering good deals. What's a good deal? How could a DUI case be resolved and disposed of? Well, I mentioned going back to, and I thank all those callers that called in. That was excellent. Thank you very much. Any other calls? We're at 1-888-565-1470. WNN 1470 radio. 888-565-1470. Now we're going back to the two cases, the DMV case and the DUI criminal case. The DMV case at stake for you, if you're arrested, is one issue and one issue alone, whether you will or whether you will not have to deal with a 6, 12, or 18-month suspension, depending on whether there are any priors in your history. At stake on the DMV case is that issue alone. I mentioned earlier how we handle that. We file a petition for a formal administrative review. We get that set up with the Division of Motor Vehicles. We subpoena law enforcement. Law enforcement comes in. They have to answer our questions under oath and on the record. And we know what questions to ask. Most competent, qualified defense lawyers, DUI defense lawyers, I should say, know what questions to ask to present to the hearing officer our best possible case to fully reinstate your driving privileges. So that's what the DMV case is all about. Yes, your license will be suspended right away, but what something law enforcement doesn't tell you is that you have a right to challenge that suspension within 10 days of the date of the arrest by having your legal team file an appeal and get the formal administrative review set up. Now, the other case is a criminal case, the DUI case. Jerry was on the line from Broward earlier when I went over the DUI penalties for a DUI second outside of 5 years with a blood alcohol content over a 0.15. In his case, it was over a 0.2. I mentioned that the filing decision is discretionary, which means a prosecutor could file it as a DUI second or could give you a break and file it as a DUI first. It's up to the prosecutor. It's up to your legal team to present arguments on how and why they should maybe file it as a DUI first. In any case, a filing decision is made on or by the arraignment date. And how are these cases resolved? Well, a lot of it depends on how strong the evidence is and what your legal team's able to do to discredit the evidence, to eliminate certain evidence. Do we have a good faith basis and grounds upon which we can seek exclusion of the breath result? Is there a basis that we could at least discredit the breath result in the sample that was produced, the manner and method in which that sample was produced? When we recreate and reconstruct the field sobriety exercises, if someone happened to do those, were they properly conducted according to the National Highway Traffic Safety Administration manual with that rigid criteria that I referred to earlier? All of these things we need to look at. Dereliction of duty and irresponsible advocacy to not do so. Those are things that we need to do. So will the prosecutor be willing to bargain and work out an arrangement that's less than a DUI? Maybe. Depending on the merits of the case, depending on what type of progress your legal team can make along the way. The next question oftentimes becomes, well, what's a lesser offense? What would be that lesser charge that I'd be responsible for? Ordinarily, it's called reckless driving. There are DUI cases that we've handled that we managed to have reduced to careless driving, which is a civil infraction. But reckless driving, it's important to note, is a criminal offense. It's a criminal offense. Now, it is possible to have the DUI charge reduced to reckless driving and have the outcome result in what's called a withhold of adjudication, which means that there's no formal finding of guilt, no formal adjudication of guilt on the reckless driving charge. So we've had DUI cases, many of them, where we were successful not only eliminating, or I should say avoiding the DUI conviction and avoiding the DUI penalties, but avoiding a conviction on the lesser charge that the person would eventually end up tendering a plea to, for example, reckless driving. If there is a withhold of adjudication on a reckless driving charge, then the person is deemed to have not been convicted of the reckless driving charge. At the end of the day, then, the client is not convicted of any offense. And what's most important than anything is that the person avoids the DUI conviction. Take it outside of the DUI conviction, take it outside of any conviction if at all possible, to avoid those nasty DUI penalties and sanctions, which I referred to earlier during Jerry's phone call. If we avoid the DUI conviction, the penalties and sanctions don't apply. However, I could qualify that and say that sometimes if the prosecutor has a decent enough case and the evidence is substantial and compelling enough, we may need to negotiate, we may need to offer up, we may need to plea bargain a little bit and offer up a DUI school in exchange for that reckless driving reduction charge, in exchange for a withhold on a reckless driving charge. Something also very important, we talked earlier about how DUI convictions in the state of Florida cannot be expunged. Well, guess what? If the case is reduced to a lesser offense like reckless driving and there's a withhold of adjudication, that case can be sealed. It cannot be expunged, but it can be sealed. Very, very important. If the person is adjudicated guilty on a reckless driving charge, there's no expunging a reckless driving charge. There's no sealing a reckless driving charge because there's no expunging or sealing any criminal conviction in the state of Florida. So very, very important that if we reach the plea bargaining stage, in other words, if we take all our arrows to try to hit the bullseye and we're not successful getting it knocked out on its own, and we reach a point where we're starting to talk about possibly having the charge reduced to a lesser offense, then we may need to negotiate, we may need to offer up some type of participation, perhaps in the DUI school, community service hours, substance abuse evaluation, what have you. But everything, all our efforts really need to be geared toward that withhold of adjudication to avoid the formal criminal conviction on your record, which is really most important. Now, there are also oftentimes civil infractions associated with that, like a red light. I call those the probable cause tickets. Sometimes folks are cited for a red light, illegal U-turn, speeding. That's the probable cause. That's the basis upon which the person is originally pulled over. Sometimes they're not. If they are, what we do up front is we file a motion to consolidate, which means put those civil infractions together with the criminal offense, and so that everything, so that all charges and citations run together in one courtroom, and eventually, most time pursuant to a plea, we're able to successfully eliminate and seek dismissal of the civil infractions, the red light, the U-turn, the blowing the stop sign, what have you. But very important to understand that all of these matters need to be consolidated up front and heard together in one court, and oftentimes that's difficult. Sometimes judges bifurcate charges and citations, and some of them don't. So so it's important that you make sure that your defense team does just that. Now, let's check the time here. Okay. We're running low on time with our hour together. We're at 888-565-1470, WNN Radio. You're listening to Musca Law Radio, streaming live on muscalaw.com, muscalaw.com. Join us every Thursday right here at 4 p.m. I'm happy to be here. It's great to be here, and I think we covered a lot in our time together. The expungement is not available for a DUI conviction. It's not available for a reckless driving conviction. Sealing is available for a reckless driving withhold of adjudication result, and that's a desired result. I oftentimes tell folks this: choice A is getting the case knocked out. The grand slam would be defeating the charge completely, achieving a dismissal, what's called a notice of no information, which means that the prosecutor declined prosecution and didn't file a charging document, or what's called a null pros after charges are filed. That would be the grand slam. If we could go for the grand slam, then obviously that's what we want. But Plan B would be the home run. If we're not successful scoring the grand slam and obtaining choice A, then choice B would be the home run, and that's seeking to have the charge reduced to a lesser offense to get outside of the DUI conviction and therefore avoid completely the DUI penalties if at all possible. Option C is third base. Choice C would be negotiating the absolute minimum penalties and sanctions on a DUI conviction. We don't want to get to Plan C. We want to score the grand slam or the home run on any case that comes in our door, and that really should be the focus and goal of any attorney that you speak to. No, I understand we're not playing games, but that's just my analogy because I think it allows people to understand perfectly exactly what our strategy is going to be. It is important if you're arrested under suspicion that you remember just that. You've merely been accused, and that the prosecutor, if your defense team has any say in it, really and truly has a long way to go in order to prove guilt. And remember, just because you blew over the legal limit, that only creates a presumption of impairment. It doesn't mean that you're impaired. And to the extent that we're able to make progress pursuing points of attack and eliminating evidence and making every possible argument that we can in your favor, that's exactly what we're going to do. So we're going to be here next Thursday at 4 p.m. WNN 1470 AM radio. As always, it's a pleasure to be here. I enjoyed it. I thought we had a much more interaction with our callers today. I thought that was excellent, and it's a pleasure to be here. But know this too: join us on our website. That's important. www.muscalaw.com, and tell your friends about us. Call in. The purpose of the show, as I indicated earlier, is to educate the public as much as possible about matters that they're otherwise unaware of, and we're here to do just that. And to the extent that I do that, I'm happy to do it. Really, I enjoy this work. I love my clients, and I'm blessed to serve. It's a pleasure, and we'll see you next week on WNN Radio.
You've been listening to Musca Law Radio with attorney John Musca, with offices throughout Florida, including Broward and Palm Beach counties. Join us every Thursday at 4 p.m. right here on 1470 AM WNN, or log on to muscalaw.com. That's MUSCA law.com, and watch the program streaming live. And thank you for joining us.